Good morning, everybody. I'm Neil Jones. I'm chairman of this subcommittee at the moment. Just a few housekeeping before we start. If you could please turn mobile phones off. I don't think there's going to be any fire drill today, so if there is a fire, then follow Mr. Twiddy and me quickly. The hearing will be live streamed, and so it's important that you do speak into these microphones. Because obviously it's recorded over there, and when you've finished speaking, to switch it off so it enables somebody else to make comments. Well, this is the adjourned licensing subcommittee from the 2nd of February. And I understand there is an application. Could I just have people introduce themselves first?
Morning, sir.
Sorry, just one second, Councillor Jones, you need to do the election of chairman.
Oh,
Apologies.
sorry, we'll elect a chairman. I thought we'd done that out there. Sorry, gentlemen.
Yeah, obviously I'll let the Councillor Jones has been chair.
Yeah, I agree. Thank you very much. So I've been elected chairman, so it's official. Right, sir, if you could, I know Mr. Dodds.
Good morning, sir. I've got Jack Staples with me to my right. He's a paralegal who's training with me. To my left, I've got Mr. Ashley Fox, and to his left, Mr. Victor Fox. Mr. Victor Fox is director and shareholder of the applicant for this, who the company's being Europa Fisheries Limited, and the factory Rock Shop. Ashley is his son.
Thank you, gentlemen.
Good morning, Chair. My name is Michael Kearney, Licensed Consultants, representing the premises licence holder, and Mr. Tajinder Singh, or Taj Bowler, who's the director of the company that holds the premises licence.
Thank you very much. And the councillor over there is a substitute in case I have a heart attack, died in the course of events. I understand there's going to be an application for adjournment. Is that correct?
Sorry, Mr. Chairman, apologies. We need to do the disclosure of interests as well, and before we can move on to the apologies, Chairman.
Sorry, I'll put it over the other side one. Do I have any disclosure of interest? No. Okay. Okay. Apologies for absence.
Thank you, Chair. No apologies received.
Thank you very much, indeed. Exclusion of the press and public. Yes.
So the chairman's just let me come in here. As far as I understand it, there's going to be nothing discussed today that you would like to be discussed in confidential session. The report pack that I've given to the committee was an open report pack, so that was placed on the council's website. The evidence pack that the members have had, there are confidential aspects of that, so that's not in the public domain. My assumption is as we go through the hearing this morning, is that we're able to have the discussions that you want to have without going into confidential session. In effect, that would mean that if the public were in the room, if we went into confidential session, they would be asked to leave the room, and the live stream on the internet would be switched off as well. Looking at what's to be discussed today, I can't see anything that I would view personally as being confidential, i.e. it's private business information or such like. But if there is things that you feel need to be discussed in a confidential aspect, probably now's the time to flag those up, and then the committee would have to make a formal declaration to go into private session if needs be at a particular time. What we would try and do is have as much as the hearing as we possibly could in a public forum, and then if there were things that needed to be discussed in private session, go into private session if the members were happy to do so. But you may feel that all of this is confidential. I don't know. We probably need both parties, if that's okay, Chair, just to flag up to you and the legal advisor whether they feel there is anything that they need or perhaps feel needs to be in a confidential session.
We've got nothing that we feel needs to be in confidential session, so.
Same here.
Thank you very much. If during the course of proceedings you do feel there is an area, then if you let us know quickly so that we can turn off the live streaming. Okay, right, can I move on now? Thank you. Yes, I understood there was going to be an application for adjournment, but if you'd like to give a little introduction first.
Thank you, Chair. So this is an application for review of a premises licence in relation to the LA Cafe on Grand Parade, Skegness. Now, the application for review was submitted by Mr. Victor Fox of Europa Fisheries Limited and the Factory Shop. And I feel that from Mr. Fox's side of things, you're perhaps going to ask the committee to consider an adjournment to a later date. So if that's one of the things you're going to ask the committee to consider today, probably is now the right time, if the chairman's happy, for you to put forward your proposals as to why you feel an adjournment would be necessary. Of course, Mr. Keng would have the opportunity to then say whether he felt an adjournment was necessary or not, or whether he disagreed or agreed with the request. And I think also Mr. Keng at some point wants to put forward an argument that he feels this is perhaps not the correct forum for the concerns that have been raised. So looking at the legal advisor, I don't know when you perhaps want Mr. Keng to put those views forward, whether you want him to put them forward when he puts his views on the adjournment, or whether you want those views a bit later, I don't know, but that's something perhaps to consider as well, Chair. Once you both had your say on whether you wish an adjournment or not, the members will retire, make their decision, and then come back if that's okay. So back to you, Chair.
Thank you, sir. You might make an application.
Yes, sir. It is an application to adjourn, regrettably. In order to explain, I do need to go through briefly the history of the case, because there was a hearing previously on the 2nd of February that was adjourned. Essentially, the crux of the representation is that there is a cantilever balcony for the LA Cafe, which extends over Mr. Fox's premises, a fish and chip shop and a rock shop beneath. The balcony has not been used for a considerable period of time. I think the nightclub closed when COVID hit back in 2020. And there is a condition on the current licence that allows the licence holder to have up to 60 people on each balcony. And there's a concern that the balcony is a real risk in terms of public safety, because there has been a considerable amount of water ingress through the balcony into the properties below. And the fear is that the water ingress will affect the structural integrity of the slab and the supporting structures like lintels and whatnot that are holding it up. And recently it was suggested that there needed to be proper testing of the balcony to see whether it could withstand the sorts of load of 120 people effectively. And at the hearing on the 2nd of February, there was a clear agreement between parties. The agreement was effectively that the licence holder was going to nominate a structural engineer or similar expert to carry out testing of the balcony for structural stability. That expert was then to be approved by the Council Environmental Health Officer, who's here today. And then that expert was going to undertake proper stress and deflection tests. There have been some crude tests that have been taking place, but there was going to be a proper scientific test with stress and deflection. And those results were then going to be sent to the council, and it was then for the council to say whether those test results were acceptable. And if they were acceptable, I'd given an undertaking on behalf of my clients that we would withdraw the application for review. And obviously, if the test results were not acceptable, then they were going to speak for themselves and show that clearly the balcony was not safe and that there was a real public safety concern. And although a hearing was fixed for today some time ago, it was not anticipated that we as the applicant were going to be playing a particular significant part in that, other than perhaps to confirm that we were withdrawing the application because the testing had proved to be to show that the balcony was safe. On the 3rd of April, just 2 days ago, Mr. Dodds disclosed to us an updated report that the licence holder had obtained from his expert. He hadn't carried out any testing. He hasn't actually seen the structure, so I understand from his report, since August when he had a 30-minute inspection. And what he'd done, he'd merely produced some calculations based on the crude testing that had been taking place. Effectively, about 8 sets of water carriers have been placed along the balcony filled with water. The weight of those carriers has been calculated. It approximately equals about the weight of 103 people, and the balcony hasn't collapsed, ergo it must be safe. Seems to be the crude process involved. And that report was sent to Mr. Dodds. He sent it to us on the 3rd of April. Firstly, that expert had not been approved in advance, which was what was agreed. That isn't a live issue because Mr. Dodds has done his research and he's happy that the expert has the necessary structural qualifications, but he didn't carry out the testing that was agreed expressly on the last occasion. No testing has occurred. And from my point of view, and I'm not a structural engineer, what's even worse is in his report, he specifically says no reliance can be placed on my findings. So he's saying, here's some calculations. I think the balcony's safe, but you can't rely on this. My concern is that on the balance of probabilities, I feel there's a real risk that this balcony is unsafe because there's been clear evidence of water ingress over the last few years, which Mr. Dodds has witnessed going down into my client's premises. There is also other evidence that raises concern. There's what I call 2 goalposts have been put up underneath the entranceway. They're rusting and corroding away. And our expert has said that's a concern, that that structure appears to have been put in place to support the concrete slab, the balcony, but seems to be corroding and therefore may not be as it should be. My client has also recently produced photographic evidence to show damage to the lintels beneath the balcony in the fish and chip shop. And Mr. Dodds has told me that he's briefly run that past building control, and they've said, yes, the state of the lintel suggests that their structural integrity may be affected, and they're dealing with holding the concrete slab up. So I would say that at the moment, on the balance of probabilities, there's a real risk that this slab is unsafe, and that the correct way to deal with this was, as we suggested last time, is to get it properly tested. And if there's clear test results to show that the slab is okay, the balconies are okay, then this application will be withdrawn. And if the test results show that it's unsafe, well, that will speak for itself. Now, it may well be, and we'll hear from the licence holder in a moment, that they've now changed their mind and they're not agreeable to having tests carried out. If they are agreeable to the test being carried out, then obviously there'll need to be an adjournment for the test to be carried out and then for the council to sign them off, the council officer. If they're not willing to carry out those tests anymore, well, A, I would say that casts a lot of doubt on their credibility. Why are you not doing what you said you've agreed to? But B, most importantly, we would need an adjournment for our structural engineer to be present. We did bring him along to the last hearing, expecting to have a fully contested hearing. And in simple terms, he was going to explain in layman's terms why, on the balance of probabilities, there's a real risk that this structure is unsafe. Both sides have produced expert reports. Mr. Dodds will tell you that they're both equally skilled, experienced and qualified. They've done their calculations, but the best and the only way to resolve this is through testing. Even the licence applicants, the licence holders expert has said, you can't rely on what I say in my report. So the application today is that we do adjourn either for proper testing to occur if the licence holder is agreeable. If he's no longer agreeable to that, then yes, we must crack on and hear the case. And it would be in the interest of justice for us to have our expert here today, as we had prepared for previously, for him to explain our position and why the structure is unsafe. The reason that he's not here today is because he was no longer going to be involved in the case, because we'd agreed that this was going to be testing and the council were going to sign it off. It was nothing to do with our expert. So he was instructed. We only found out on the 3rd of April that the test hadn't occurred. We had no opportunity to get him along today. He has produced a brief report, which you may have seen, commenting on the report that's been produced, where he's still saying, I'm unhappy, this isn't satisfactory, but unfortunately he's not able to come today and explain things. So I would ask today that we do adjourn to the shortest possible date. If no testing is going to take place, well then hopefully we can hold this, reconvene this very shortly. I just need to get my experts' availability. If the licence holder is going to do the right thing, in my opinion, and get the structure tested, then obviously we may need a slightly longer adjournment for that to take place. I understand that there may be some suggestion or comments that this isn't the right forum for this issue. I would argue that it is. Last summer, when this first arose, I spoke to Ian Henton, who was the surveyor in the East Lindsey Building Control at that time, a very experienced chap. And basically he said that unless the structure was actually in the process of collapsing or had collapsed, there wasn't anything that he could do from a building control point of view, and that he felt that we should proceed with the review application. The licensing objectives, one of which is public safety, is clearly relevant to this issue. We're going to have members of the public attending at this nightclub, standing on a structure. Is it safe? It's clearly within the Licensing Act regime. When I attended last time in February, counsel for the licence holder suggested that this should be something that should be dealt with under the Health and Safety etc. Act 1974, because the council does have certain obligations to the public. But when I asked him, well, what particular provision should the council be looking at, he couldn't tell me. And when I've asked the council officers, they're not able to tell me. And pardon the expression, but we've been going round the reeking. Nobody's been taking responsibility for looking at this. So I would argue that this is the correct forum for dealing with this matter, and it's within your remit to look at it. And if it doesn't get looked at within this forum, then what's going to happen? Who is going to look at it? Under what statutory regime is this going to be considered? So those are my submissions. I would respectfully ask that we do adjourn this case. For how long depends upon whether the licence holder is willing to carry out tests that he effectively promised and agreed to do last time but hasn't done.
Thank you. Mr. Kane.
Good morning, Chair. We did agree to some testing. We do strongly oppose an adjournment. We did agree to testing. We didn't promise we would do testing. We agreed that we'd do some stress testing. I think everybody, there was only one person in the room at the time that probably fully understood. Well, I'm not even sure there was one person in the room that fully understood what deflection testing was. It was deflection testing, not stress testing, that we were looking at. We agreed that we would look into doing some deflection testing of the balcony. Mr. Bowler tasked me personally to try and find a suitable company that could carry out the testing. I contacted two or three I contacted quite a lot of companies, but 2 or 3 companies did come back to me and said it was pretty pointless doing the deflection testing because the deflection had already occurred. What Mr. Bowler had done at the beginning of January is put 8 IBC containers full of water on the balcony. Those 8 containers equate to 130 people, not 103 that Mr. Shackleton said on the balcony. They were in place up until late February. 2 of them have been emptied since, and there's 6 of them still full. So there's the equivalent of just under 100 people's worth of weight still on the balcony today. The companies I spoke to or came back to me regarding the deflection testing said it was pretty pointless to do the deflection testing because any deflection would have already occurred. Deflection testing really is What they would do with the balcony is they would do exactly the same as we've done. They would line the balcony with a membrane, and they would just simply fill it with water. And they would measure it if there was any deflection that had taken place without the water to when the water was there. They said to me, because we'd already, in essence, put the water on the balcony, that the deflection would have taken place. So the only way that they could actually carry out the testing would be to remove all the water, wait several months for this balcony to go back, and then do the complete exercise again. And because they obviously are wanting to protect themselves against any liability if anything happened, they would have to erect a crash pad underneath the balcony. Now, a crash pad is a scaffolding framework that would catch the balcony if it fell. So it'd be a substantial structure that would go under there, and in essence, it would close Mr. Fox's businesses. So I can't speak for Mr. Fox, but I don't think he'd be too happy if we closed his business during the summer, because his request was to put this, have this deflection test done and have this crash pad built underneath it. And that's the only way we could do it. We then went back to our engineers who provided the original report and said to them what we'd done, and said to them, what do you think? Is this right? Can we do a deflection test later? We've done this. And they said exactly the same. You've put the weight on there. Any deflection now would have taken place. And on the telephone, he said to me that, if it wasn't safe, it would have come down by now. But you can't do a deflection test until you've unloaded the balcony, you've left it for a period of time, and then you carry out the deflection test then. He then put that in his letter as an addendum and sent it over to me, which I then forwarded over to David to say, this is where we're at. We can't find anybody to do a deflection test. We agreed that we'd do a deflection test, but it's quite apparent nobody in that room knew what a deflection test was. I certainly didn't. And by talking to engineers who do know what they're talking about, they clearly said we couldn't do it. I would question the report that Mr. Fox has had produced. It does state in there, in 3 places, it says, no major distress on the concrete edge of the balcony, no evidence of any major structural movement, no evidence of major distress was apparent. So Mr. Fox's engineer is saying that in those 3 sentences, he doesn't really think there's a problem with the balcony. Yes, there may be water coming through. We've had a photograph of a lintel. We don't know where that lintel's come from. With no expert witness that's provided that. I think to insist that Mr. Bowler has another report done is not acceptable. We have had the weight of 100 people plus for over 3 months on the balcony, and it's not moved, it's not fallen down. There's been no signs of any cracks or anything else like that. And I think one of the most important parts from your aspect is you're sat here today as a licensing subcommittee dealing with matters under the Licensing Act, provision of alcohol or regulated entertainment. Mr. Bowler could open the upstairs as a fish and chip shop if he wanted. He could put 200 people on that balcony if he wanted, if he wasn't selling alcohol. So by you taking measures under the Licensing Act, this is why we say this is the wrong forum. And I really appreciate the hard place that Mr. Twiddy's been in to accept or not to accept. And I think that the general rule of thumb and the guidance is that you have to err on the side of caution as a licensing officer and accept a review unless it's so far away from being, unless it is obviously vexatious or frivolous, and we would say this is a vexatious review that's been applied for today. So it doesn't matter what you decide if we proceed and if you decide that the balconies shouldn't be used, if you decide that the balconies do need another report doing, we could simply just not use the premises license. We could open it as a fish and chip shop, as a tea room, and we could fill that balcony with people. So the putting my client to the expense of having another report done when we've already proven that we can have these people on that or that weight on the balcony, I don't see why we need an adjournment. In regards to people not being available today, Mr. Bowler wanted counsel here today. They were already booked, so we couldn't have them. You know, we're not asking for an adjournment just because counsel aren't available. Everybody's been aware of the date of this hearing for a while. So we would say, you know, we need to press on. To adjourn is only really going to incur costs and time for my client. It's going to incur cost and time for the taxpayer, because these meetings aren't put on for nothing. It's going to cost the taxpayer for another hearing and your time as well. So we'd ask that the request for adjournment is refused, and we would also ask that, bearing in mind that licensable activities don't have to take place. If the license wasn't in place, we could use this balcony. We could use it with more than the 120 people that the premises license states at the moment. That the application really should be dismissed.
Thank you. Mr. Twitty, do you want to make any comment before I?
No, Chair, I think probably it's best for you to take the advice of your legal advisor and probably retire and decide where you want to go in relation to the request for adjournment. Thank you, Chair.
Have you any questions, Councillor?
Not at this stage, no. Excuse me, could I just respond briefly
Yes.
to some of the comments that my friend made? In no particular order. The calculation says 130 people, but actually it's an arithmetical error. It's 103 people if you check the ML consulting calculation. So if the expert has made an error in his mathematics, one could query whether his conclusions are correct. It was absolutely crystal clear last time that stress and deflection tests were taking place, and that Mr. Bowler was to ensure that the water containers were going to have to be removed and the process was going to have to start again and be done properly. And there was a discussion about how the engineers use various types of surveying guns and gouges to measure. And there were lots of conversations about this. So I don't accept that suddenly we didn't realise what we'd agreed to, or there was a difference of what we'd agreed to. I don't accept that. Also, if genuine inquiries have been made, as has been suggested, why weren't we told about this earlier? Why is this only suddenly on the day? Why weren't we told back in February or March that the experts that have approached have said there's no point doing these tests, or you can't do these tests? And our expert says yes, you can do these tests. And in his recent report, he's provided a link to a company who are willing to undertake the tests. And our expert was of the view that it wasn't necessary to have these crash pads, as has been discussed. But if it is necessary, then it's something my client would consider. The bottom line is, if Mr. Bowler isn't going to agree to the tests, I don't think we can force his hand, and we have to proceed with the application. But I would ask that it be adjourned today, because, as I say, our expert was deborn because it was agreed he was no longer required. We need him here. In terms of not having counsel or solicitor present, there's lots of solicitors and counsel who could have attended. The argument about, well, if we turned it into a fish and chip shop, couldn't do anything about it. Well, I'm afraid, whilst it's being used as a licensed premises, it is regulated, and this council is responsible for it. And if it's going to open up and alcohol is going to be sold and consumed and regulated entertainment is going to take place, well, then it fits firmly and squarely under your remit to be responsible and to control what is going on so far as possible in that premises, so far as the licensing objectives are concerned. And it concerns me that Mr. Bowler's attitude to this is, I could just open this up as a fish and chip shop. Does he not realise that this is a serious matter, and that this balcony could be a serious issue for public safety? And it worries me that he could make such a flippant comment, well, I'll just open up as a fish and chip shop and we can have hundreds of people on there, when there's clearly issues that need to be addressed. And one point that I missed out, that I omitted to mention, the balustrade that has recently been constructed. You've seen the photographic evidence. There's been a very crude push test applied to it. The fixtures to it, according to my expert, and in my eyes, I agree with him, don't look sound, some of them look loose, some of them are close to the edge, some of them look insecure. And proper testing of the balustrade is required because, as you well know, if you get 120 people on that balcony, there's a chance that a fair few of them are going to lean against that balustrade. And a push test, in my opinion, is not going to satisfy you on the balance of probabilities that that balustrade is safe, bearing in mind some of the fixtures and fittings on that don't look as good as they should be. It's not going to be any real expense to have that properly tested, and that can be witnessed by a council representative. And again, if Mr. Bowler isn't prepared to have that testing carried out, then I would like my expert to be here to make representations to you as to why, on the balance of probabilities, that balustrade is unsafe, and therefore the structure is unsafe, and therefore it shouldn't be open to 120 members of the public. So I would urge you to adjourn if it seems the testing option is now something that's not going to be offered. Then we do need to crack on with this. We would like to have our expert present. We can get his availability to the council very quickly, and we can hopefully have a hearing within days or weeks, depending upon everybody else's availability, sir.
Thank you. Martha, have you any comment?
I think given that Mr. Shackleton introduced some new evidence about the balustrade, it's only appropriate to ask Mr. Keng and Mr. Bowler if they've got anything additional to say about the balustrade, just so everyone's had an equal say on all matters. Thank you.
Yeah, thank you for that. Firstly, apologies, it is 103, not 130. There is a typo. I look back in my notes and my notes just say 103. So I'll stand corrected on that. In terms of the balustrade is incomplete at the moment. It's not being finished, and it will be tested once it's complete. I think if you look at any sort of testing, sort of balustrades and everything, I think there is a section in the guidance, which was in your report, that says that that's not within your remit. It'd be like you putting a condition on a premises license saying fire doors must be to British standard, whatever the number may be. That is not the case. And indeed, I think if a review is brought, there should be evidence supplied to you. It shouldn't be we want a review and therefore we want the license holder to go and find the evidence. If you had a problem with noise, I'm pretty sure that David wouldn't be putting a review in saying, oh, we've got a problem with noise here, can you go and sort it out? We'd be saying, well, where's your evidence? They would come with evidence. If we had a review from the fire service about fire doors being blocked, they wouldn't come to review saying, we think your building is dangerous because the fire doors are blocked. They would come with evidence to say your fire doors are blocked. So it'd be really for the applicant of the review to give you hard evidence, and there just is none. If we proceed, which I hope we do, or unless you decide to dismiss the application before it starts, we will go through the report that's been produced by Mr. Fox to show you the flaws in that report. So I don't think we can actually rely on Mr. Fox's report. But in terms of the balustrade testing, I think that's a matter for the premises license holder, the business. A very responsible business. They've invested millions of pounds into Skegness, £6 million plus next door at the Hive. They've recently bought the town hall, which they're going to convert to a hotel in a very down market at the moment. And they've also got the other hotel, the Royal in Skegness. You know, we're not talking about a business person here that likes to do things and be negligent and offer whim or anything else like that. You know, the balcony has been tested with weight. It might not have been done by an engineer, but, you know, the engineers that we've spoken to have now said, well, you know, there's not a lot really you can do because the weight's been there. You take the weight off, wait a few months, then we can do the tests. But yeah, in terms of the balcony testing, it's like any other part of a building that a business would do. That's not really that's not your remit here. That's down to the business to make sure that everything is safe within their premises.
Thank you. Martha?
I think it's time for you to retire, Chairman and members, to decide on the adjournment.
Thank you. We will retire and make a decision.